seated, please. All right, we are back on. Defense present. From the state.
Thank you, Judge. Mr. Goff talked a lot about citizen's arrest, and that being the defense in this case, but there hasn't been any evidence that anyone was making a citizen's arrest. Citizen's arrest was never said by any of these three defendants at any point in time. The evidence that's been presented is that Mr. Bryan and Mr. Gregory McMichael never once said, we were making a citizen's arrest, that we're placing him under the arrest for the crime of this, that we saw him commit a crime that day. That was not it. It was all, we wanted to stop and talk to him, and then we wanted to detain him. In fact, Mr. Rubin said in his opening statement that the intent was to detain him so that the police could show up and do whatever they were going to do after the detention. It's not citizen's detention, it's citizen's arrest. So while he talked about that, that is really not something to be considered in a directed verdict motion. And just because a set of facts hasn't yet been specifically identically brought before a court, these sets of facts, no two cases are going to have the same set of facts. They're just not. And so the fact that there is felony murder based on false imprisonment case law out there, where someone has been found guilty of felony murder based on false imprisonment, someone's been found guilty as a party to crime based on aggravated assault with a shotgun, someone's been found guilty of party to a crime for aggravated assault with a motor vehicle. Those cases are out there, maybe not with these specific facts. So that argument doesn't really hold water either. In this particular case, when it comes to Mr. Bryan, and this will apply for all of the charges here, once again, it's party to a crime, and that means intentionally aid and abet. His statements to Agent Seacrest and actually at the scene to Officer Minshew were about, I thought they had done something, I thought I was trying to help them get this guy, false imprison this guy, capture this guy. And that was what his intent was. It was to falsely imprison this particular person, and he intentionally used his vehicle to go ahead and do that. Both on Burford, when he intentionally committed an aggravated assault, putting Mr. Arbery in reasonable apprehension of receiving serious bodily injury as part of his attempt to falsely imprison him on Burford. Those two things contributed to his death because but for those things happening, Mr. Arbery would still be alive. So it is, as the pattern charge will be given, his actions played a substantial and necessary part in causing the death, because without him doing those things, Mr. Arbery would not have been trapped like a rat over on Holmes Drive between the two pickup trucks. As we noted before, Malice chased him through the public roadways in the pickup trucks, tried to stop him, cut him off with the pickup trucks. He drove him into a ditch. He assisted pinning him between the two pickup trucks, trapping him like a rat between the two pickup trucks. Mr. Arbery had not threatened anybody, had shown no aggression. Mr. Arbery had no weapons. He was totally unarmed. And here, Mr. Bryan never called 911. He continues pursuing Mr. Arbery. Mr. Bryan never says anything on the recording. He pulls forward despite the shotgun coming out, despite the shotgun being pointed at himself, doesn't slam on the brakes, doesn't yell, doesn't protest, doesn't honk, just keeps driving forward, driving Mr. Arbery forward. He helped to get Mr. Arbery to this location by redirecting him up Holmes. The most important thing is when you have common criminal intent, and here the state's position is that as parties to the crime, there's common criminal intent to attack Mr. Arbery via false imprisonment, aggravated assault with the pickup trucks, aggravated assault with the shotgun, and false imprisonment ultimately on Holmes. And that common criminal intent to do all those things, not necessarily the conspiracy. I'm not talking about conspiring in advance and coming up with a plan as we sit around the kitchen table. We're talking about what they actually did, acted in concert with each other. The white truck came down Holmes. Mr. Bryan was going up Holmes. Mr. Arbery had already turned around and was running back, and the white truck passed him. Mr. Bryan did not abandon this. He turned around. He kept going, and then he accelerated to catch up to Mr. Arbery, passed the blue mailbox, saw the shotgun, and kept going. Common criminal intent, which resulted in malice murder, resulted in all the felony murders. All of his actions did substantially contribute to the death of Mr. Arbery, and they were necessary, because without those actions, Mr. Arbery would be alive. We ask that you deny the directed verdict for all of the counts as to Mr. Bryan. Thank you.
Any final word from Mr. Bryan?
Your Honor, when the state is constrained to acknowledge that they have no legal authority for their position, for example, on malice murder, then I think the court should take seriously the motion to grant the directed verdict. There is no malice murder case against Mr. Bryan. With all due respect to the state, there never was. That there are some other issues in the case that are more challenging and more troubling. But that's an easy call. I think it's an easy call on count 2 felony murder for Mr. Bryan only. Again, the state has no it doesn't even pretend to give an explanation as to how Mr. Bryan, thinking that he's aiding a citizen arrest lawfully or unlawfully, how that translates into an intent to shoot or an intent to injure. And it's deeply troubling to me that the state can't have the candor to acknowledge to the court that maybe in retrospect, counts 1 and count 2 as to Mr. Bryan were not well thought out. There's no proximate cause. There's no reasonable foreseeability here. I'm impressed with the argument that was made. But still, Mr. Bryan is entitled to a directed verdict, certainly on count 1, almost certainly on count 2, and arguably as to every count in the indictment. Thank you.
And Your Honor, I apologize profusely. I had pulled up the case and I forgot to cite it. And it is both the state of Georgia, Moore versus the state and Milburn versus the state. It is 311 Georgia 506. And in this particular case, a group of men wanted to rob a drug dealer, and one person stayed downstairs to keep the boyfriend away while they went up to go ahead and search the apartment. Unfortunately, the girlfriend was in the apartment, and the 2 that went up there, one executed the girlfriend. They came downstairs. The state obtained a malice murder conviction on the man downstairs who simply kept the boyfriend from protecting the girlfriend upstairs. And that is a case that does show someone who doesn't have their finger on the trigger, who's downstairs doing some other action, the same sort of criminal intent, which we feel that's here, same criminal intent to falsely imprison, aggravated assault with the trucks and with the gun, can be convicted of malice murder. And that's the case we cite to. I apologize for not having brought it up further earlier.
I'm sorry, was there a citation for Milburn, or are we abandoning that at this point?
No, Moore and Milburn are co-defendants, and it was a combined case, and
Okay.
so it is the same case. 311 Georgia 506 out of Cobb County, 2021.
Again, Your Honor, that case doesn't even get close here. That is in line with the other cases, what I call the distraction line of cases. It's basically the same thing. In this case, it's distraction plus, in that the person who's being charged is holding, basically, a third party who could otherwise and would otherwise go to the defense of the person who's killed. Mr. Bryan is sitting out there in his truck armed only with a cell phone. He's not holding anybody back. He's not saying, Mr. Albenzi, you stay back there. There's nobody else on the scene. This is a case where someone is actively preventing this. Moore v. State is a case where someone is actively preventing a third party from coming to the aid of the person being killed upstairs. That is completely irrelevant and totally off base. And again, Your Honor, if that's the best the state can present to the court, then I think the court is constrained to grant the directed verdict as to count 1.
I've heard the arguments and presentation of counsel on the motions for directed verdict under 1791A, the court considering the appropriate standard after the state's rested is denying the motions for directed verdict of the McMichaels defendants, the collective motion made by Mr. Hogue, as well as Mr. Bryan's motion for directed verdict as presented. The court also has the demur to address. So the court, having reviewed the demur, it looks like it does raise a slightly different issue than what had been presented previously in the demurs that had been filed, specifically the contentions that count 7, and this is paraphrasing, combines multiple violations or different violations under the same statute in a variety of ways with numerous defendants. This is the allegation. In such a manner that cannot be reasonably countered at trial. And I've reviewed count 7, which does apply to all 3 defendants. It's the aggravated assault. In this particular case, the defendants are charged as parties to a crime. Having reviewed the language of the indictment itself, it is in the conjunctive. Court, looking at cases such as Moore v. State, 319 Georgia App 696, and Straker v. State, 259 Georgia App 904, as well as Muhammad v. State, 307 Georgia 89. After considering the submission of counsel as well as arguments made, denies the demur. The next matter I have before the court is the defendant's presentation of evidence and choice to testify. So what I'm planning to do is get into Mr. Bryan's opening statement and then get right into evidence. I'm assuming we would start with Travis McMichael. I didn't know whether there was going to be a combined presentation. Has there been any discussion about that?
Joe, we're going to begin with our witnesses, and so to the extent that they serve both Travis and Greg McMichael, they may or they will. And I think that we will be handling all of the witnesses for that joint kind of presentation.
I'm just trying to think of how that then is presented as we get started with the jury.
And it would probably be something to the effect of we rest, and then if the Hogues need to do anything, then they could, or they would just say we also rest, and then Mr. Bryan.
Okay. That makes sense. I understand how we'll present it then. Then I guess with that being how we're going to move through this. Go ahead, Mr. Goff.
Your Honor, we do have 2 matters to put on the record before we bring the jury back in.
Let's get through what I'm trying to get through that. What I'd like to do then is, has there then been discussion, counsel for Travis McMichael, about his right to testify and his intent with regard to testimony in the court?
Yes, we've discussed with him that he has the right to testify or not. He has expressed to us that he understands that very clearly, and he will elect to do so or not do so. The court certainly can inform him that he has the right and that he's presumed innocent and all that, but we've discussed that with him already.
All right.
The court wants to make sure he's informed, right?
Right. I want to make sure he's informed. So generally what I'll do is swear the defendant in and walk through a few questions to make sure that I'm comfortable with his understanding of what his rights are, since it is his decision and his decision alone to testify. Right. So that's the court's general course. We can do that. I guess what you're saying is at this point, no decision's been made, or there has been?
We're asking the court not to ask him if he's going to testify or not, but the court can inform him of his rights.
Okay. Well, I might have to circle back then as we get into the evidence just to make sure that I'm clear about where we are, but I would like to generally make sure that that discussion has occurred.
Yes, Your Honor, the same thing. We have made Mr. McMichael abundantly clear, and of course he already was aware of his rights, the dangers, the pros, the cons, and he understands that it is his decision to make. But we would not be allowing, respectfully, the court to inquire of him of that decision until he's made that decision. He'll either take the stand or he won't, and that will inform the court and the rest of the folks of what decision he's made.
Well, I might wait then to swear the defendants. My understanding then the representation, well, no, let me just do this. I'll make it a much more general inquiry then, just to make sure that the defendants have had that opportunity. If they wish to take any additional time, they can do so. All right. Let's do that then. What I'm going to do is just swear each one of the defendants in for the limited purpose that I just described, and we should move through this relatively quickly. So, if I can get all three defendants just to please stand. Swear to tell the truth, whole truth, and nothing but the truth. Yes. I do. I do. That's a yes or no. I do. All right. Travis McMichael. Just want to make sure that you understand before we get started that I have no opinion on this whatsoever. The only reason that I've sworn you in this morning is to make sure that I have a understanding of your knowledge with regard to your right to testify in this court. I'm going to ask you some questions. None of those questions are intended to ask what specifically you have discussed with your lawyers. You have a privilege with your lawyer. I want just some basic understanding of what you know about your right to testify in this court. Do you understand that?
Yes, Your Honor.
All right. What is your highest level of education?
12th grade, graduate high school.
All right. And I understand you have already spoken with your attorney already about your right to testify in this court.
I did.
And you understand that you do have a right to remain silent in this court?
Yes, Your Honor.
And what that means is that you have the right not to take the stand and testify, and nobody can make you testify in this court. Do you understand that?
That's correct. Yes, sir.
The right to testify in this court before this jury is your right, and therefore it ultimately is your decision and your decision alone whether you do or do not testify. Do you understand that?
Yes, Your Honor.
No matter what your lawyer may have told you, and again, I don't want to get into any of that, ultimately it's your choice.
That's correct.
You understand that if you do testify, you'd be treated like any other witness in this court, which means that not only would you be able to testify on direct examination with your counsel, but you would be subject to cross-examination by the state.
Yes, sir.
Do you need any additional time to speak with your lawyer about your right to testify in this court?
I do not.
All right. Thank you, sir.
Thank you.
Thank you, Your Honor.
Mr. McMichael. Again, I have no opinion either way. You understand that. I won't go through all that prefatory that I just did with Travis McMichael. Again, I'm just trying to ensure that you understand what your rights are before this court. With regard to your education level, what's your highest level of education? Okay.
I'm calm.
And I understand you have already spoken with your attorney already about your right to testify in this court.
I have.
You understand you do have a right to remain silent, and that what that means is you do not have to take the stand in this court. And I probably should have mentioned when I was going through this with Travis McMichael, if you choose not to take the stand in this case, the court will instruct the jury that they can't hold that against you in any way. Again, lawyers, you've had this discussion with your lawyers. You understand, though, ultimately is your decision and your decision alone whether or not you do or do not testify in this case.
Yes, Your Honor.
And have you had a full opportunity to discuss the matter with counsel?
Yes.
Do you need any additional time to speak with counsel? All right, thank you, sir. Mr. Bryan. Again, what is your education level?
12th.
And again, you do understand that you have a right to remain silent in this court,
Yes, sir, I do.
that you cannot be compelled to testify before the panel if you don't wish to.
Right, yes, sir.
You can testify before the panel. You understand that?
I understand.
And the decision to testify or not testify is ultimately your decision and your decision alone,
Yes, sir.
no matter what you may have discussed with counsel.
Yes, sir.
And did you have a full opportunity to discuss with counsel your right to testify before this court?
We have.
And you understand that if you do testify before this court, you'd be treated as any other witness, which means that the state will cross-examine you.
I understand.
And you understand that also if you choose not to testify, the court will instruct the jury that that cannot be held against you in any way. Do you understand that?
Yes, sir, I do.
Do you need any additional time to speak with counsel about your right to testify in this court?
No, sir.
Thank you, sir.
Thank you.
Mr. Goff, you indicated you had 2 matters before the panel comes back.
Yes, Your Honor. Since we last broached the subject, I would note that an individual that matches the general height and build of Pastor Mark Baker, a local pastor, I believe in jury selection, he was referenced by one of the jurors or potential jurors as having had the Attorney General of Georgia, Chris Carr, as a guest at his church where this case was discussed. I saw what I believe was that young gentleman, a pillar of our community, I would add, in the back of the courtroom yesterday. And I can't say that I see him now, but I thought I saw him out in the hallway. I would also note it's unclear whether he is a member of the Community First Planning Commission, one of the 21 black pastors. Of course, that is not just black pastors. There are other white pastors who've been in and out of the courtroom. I believe yesterday afternoon, I could be mistaken because I've never had the pleasure to meet her personally, but I believe our local rabbi, a white female, who's also been active in the social justice movement here, for lack of a better word, was present in the back of the courtroom. Given the court's rulings, and I'm not questioning the rulings of the court, of course, we're unable to document who actually is in the back of the public gallery, in the back of the courtroom. But then this morning, I believe, as much as I'd like to see him, I regret the circumstances, the Honorable Right Reverend Jesse Jackson is here yet again in the back of the courtroom. And there has been no indication yet from the state or anyone else that he is actually here in a capacity as a minister, given his remote location from this area. I am, again, separately and independently from any of the prior motions for mistrial, moving for a mistrial in this case. Again, the developments of yesterday afternoon and today, in conjunction with all that has gone before, reasonably called into question whether the defendant Bryan can receive a fair trial in this matter, notwithstanding the best efforts of this court to ensure one. And we are therefore moving for, again, for a mistrial.
Anything from the remaining defendants?
We're not joining on mistrial, Your Honor, but I think that it's prudent to recognize the limitations that the court set for who will be sitting in these rows, and that we do have the overflow room for the general public. I think it's been made abundantly clear that the people who are joining the Arbery family are part of a larger conversation that is happening nationally, that has been funneled down into the community, and so they represent a national conversation that is for the conviction of the defendants. And for that reason, I think that they should not be present in the courtroom where the jury can see them and be reminded of the national conversation. That is an improper influence on the jury to the extent, and I'm sure that they would recognize throughout the course of their lives, that they have had this type of impact on communities nationally and locally. And for that reason, I think it's more prudent to have them join the public in the overflow public room so that the risk of influence isn't present. Thank you.
Greg McMichael joins Travis McMichael's motion.
That would be the remedy that we're seeking.
Anything from the state?
There's absolutely no evidence that these jurors are aware of any national conversation about the conviction of these defendants. So to say that this is having an influence on the jurors assumes facts absolutely not in evidence. The assumption that there's some improper influence because some people are sitting in the back of the courtroom, there's been no evidence of that. And we leave it to the discretion of the court, Your Honor.
All right. The court's denying the mistrial. I address Mr. Sheffield's point. During jury selection, these particular members of the panel, the entire panel, I should say, that was before the court over 3 weeks was extensively, I don't want to say examined because that makes them sound like witnesses, and I've equated that before, but they were asked quite a bit about their backgrounds as part of the vetting process for this jury. And in fact, a lot of that went further than this court may have thought necessary, but it did delve deeply into many beliefs that they have about what is going on in this community, as well as with regard to organizations such as Black Lives Matter and various other things. So that has been vetted through the court, and I'm comfortable that that process has resulted in a panel that is willing to listen to the evidence and only the evidence that is presented in this courtroom. I've already ruled upon the presence of certain individuals in the court. I'm not going to go back over that, but I'm denying the mistrial for the same reasons that I've done before. I will note that the court has put restrictions on what folks can actually wear in the courtroom. We're not doing any buttons or face masks or anything like that. Everybody is here complying with the court's orders. There is also a order in place that governs seating in the courtroom and seating in the overflow room. And as far as I'm concerned, that has been complied with. That's the court's order that I put in place about a week, maybe 2 weeks, could have been longer, before the trial started, to help address some of the concerns that were voiced prior to trial. So since everybody's complying with this court's orders, and since the court is comfortable that we have a panel in place that will listen to the evidence that is presented and not be influenced by factors that may or may not be appearing in the courtroom, and I'll note, just so that it's clear, I believe that the Reverend Jackson is in the courtroom. With all due respect to whomever Mr. Goff was addressing before, I don't know who that is, but the court's position, I think, has been made clear. Are we ready to get the panel?
Not quite. The second motion, Your Honor. And that is a motion that relates back to issues that were discussed by the court with counsel before the trial started, I believe. And this motion is based on the developments during the trial of this case. We don't think the record is, at this point, adequately documents whether jurors have been contacted or otherwise exposed to improper influences. I think that it's probably at this point insufficient to just let the jurors bring matters to the attention of the court. It's probably something for the balance of the trial the court should consider inquiring on the record, or however we're going to do that to preserve the record. When we actually prepared the written motion that was filed on the matter the court's already addressed this morning, the ingenuity with which individuals over time, from the anti-civil rights organizations to organized crime to whatever, there just seems to be so innumerable ways to influence jurors. Sometimes they're not even aware of it. Sometimes it's not even clear till after the fact. We think the court, it's incumbent on the court to better document the situation with the jurors on a daily basis, and in support of that, I would start by go ahead and tendering as an exhibit. I was kind of surprised it didn't come up during Officer Rash's testimony, but he was my witness. Now, court reporter can mark this as whatever exhibit next is for Mr. Bryan, and I'm going to provide a copy to opposing counsel. Hopefully there'll be one left for me when I'm done. Your Honor will recall the testimony of Officer Rash at the very conclusion. I believe it was the last question or two on redirect from Ms. Dunikoski. She asked Officer Rash whether there was some litigation and whether it would affect his testimony. And of course he said no. And of course he's subject to recall, and whether we go back to Officer Rash or others go back in rebuttal, it's not for me to say. But there is in fact a federal civil lawsuit involving Officer Rash and the defendants in this case, as well as District Attorney Jackie Johnson and Waycross District Attorney George Barnhill, filed by Wanda Cooper in her individual capacity as administrator of the estate of the decedent Ahmaud Arbery. That complaint, and it's copied, you're reading left to right instead of right to left on the page numbers, Your Honor. But basically, this is a lawsuit that spans 45 pages and approaching 300 paragraphs. Your Honor, it is a suit essentially making claims that are substantial. I would also note, and we certainly can try and print stuff online, I think it's pretty much common knowledge at this point, at least in Brunswick, that the 223 Foundation raised or claims to have raised $2 million for the estate of Mr. Arbery.
Where are we going with this?
I'm going, Your Honor, that this is a case in which there are a lot of resources out there, and there's a lot of things in play, and we think that, for example, the same lawyers involved in this case just settled for $27 million a lawsuit involving George Floyd. There's a lot of money floating around out there, and I'm not saying that anybody's using that money improperly. I haven't alleged that. But I am suggesting that under the circumstances of the case, that it would be appropriate to heighten at this point, based on the developments as the case has progressed, the court's inquiry or protection of the jurors from improper influence. I would note that none of us, including the state, no one has asked to sequester this jury. And I'm not asking the court to do that now. But we do have an unsequestered jury. And I think that under the circumstances, given the history in the George Floyd case, and I don't mean any disrespect to Mr. Floyd, I guess technically I should call it the Chauvin case, issues arose, things that came out after the fact involving, I believe, one of the jurors, issues involving elected officials, consciously or unconsciously, perhaps influencing a sequestered jury's verdict. I think there's enough basis in this situation, and given the developments during the trial and what is anticipated to be a massive event outside the courthouse in the morning, that the court step up the efforts taken by the court to ensure the sanctity of our jury process. These jurors have certainly never been exposed or involved in a case like this before. So I've made my motion.
This is the same motion that was made by Mr. Hogue earlier in the case. The court initially indicated that we use that process, but the court and I informed counsel that I'd reconsidered that process and that I was comfortable with the way the court has been moving forward here, which is every evening before we break, making very clear and repeating the court's instruction with regard to any outside influences and asking that they be reported immediately upon their return. I have not received any of that from the panel, and the court's position remains that there are safeguards in place to ensure that that is not occurring. I understand counsel's concern, and that is the reason we're asking, or I'm telling them every night, what the court's specific instructions are with regard to any outside influence, discussion in the case, picking up newspapers, addressing social media, addressing anybody talking to them, addressing anybody actually speaking in their presence of hearing, and reporting that back to the court. That's why they received that instruction. So the court intends to proceed that way.
And for the record, they don't think I tendered a copy of the federal civil law. So I gave it to the clerk, and I could see the blue tag on it. And, Your Honor, the federal civil lawsuit has been tagged, identified as Bryan Exhibit Number 51? 51.
Any objection?
I don't tender that at this time.
No, Your Honor.
There you go.
I think you'd rather I give this to the clerk.
Any one more from Greg McMichael?
No objection.
Submitted. All right. Understand then. Mr. Goff, you ready for your opening statements?
I believe we are, Your Honor.
All right. Let's go ahead and get the pen. And Mr. Goff, just to zero them in, I'm going to remind them that you had reserved your opening statement to the close of evidence.
Yeah. Ms. Bird, she needs a chair over there by the equipment.